Good morning, everyone. Happy Monday morning. I am Carol Williams with Williams Immigration, and we are back for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, the first thing I want to talk to y'all about is a policy update, or I guess really sort of an announcement. It is a policy update that essentially says that if initial evidence in an immigration filing filed with USCIS is not provided, then USCIS isn't, they're not really required to send out an RFE, which is a request for further evidence, or a NOID, which is a notice of intent to deny. They are giving the officers the ability to just simply deny the application. So I've seen a lot about this. I have a few things about this. One, it's not really new. This particular administration has said this before, that, issuing RFEs and NOIDs is not sort of always going to be the norm. And so when an application is missing initial evidence, that it will, that it does have the ability to just go straight on to deny the application without really giving you an opportunity to give them initial evidence. So when I say initial evidence, think of basic evidence, sort of like the bare bones minimum of what needs to be backing up your application. I'm not talking about some of the more nuanced questions that USCIS has when they issue an RFE trust, but I'm talking about, and they are talking about sort of that basic information. Sitting on a denial does not feel good, certainly, but they are not talking about, when they say initial evidence, they're not talking about some of the more nuanced pieces of evidence or nuanced questions that they have about applications. So, I know my friends and I, colleagues and I, we have been sort of operating under this assumption for quite some time. So if anything, it is a good reminder that an officer does not need to provide an RFE or a NOID. The other policy alert or announcement that is recent from last week is it is allowing officers, immigration officers, USCIS officers, to suggest DNA testing. So if you are filing an application and you're looking for sort of a different way to show relationship other than a birth certificate, maybe you don't have the birth certificate for whatever reason, DNA testing is an option. Now, DNA testing is tricky in that if one person is in the United States, the other person is overseas, there is a process to having that done, and having it done correctly such that USCIS will accept it, but it is an option. So that is a policy alert that came out, I think it was last week, that we can use DNA testing to show familial relations. If you have comments or you'd like to submit comments on either of these policy updates, they are being accepted until September 7th. So if you would like to make a comment on those, you are certainly obviously welcome to do so. The next thing I want to talk to y'all about is the visa bond program. So it started as a pilot. I guess they liked it. So now they have published a final rule, which took place immediately. So it's in place now, whereby individuals from certain countries will have to pay a bond when they are receiving their B1, B2 visitor visas. That bond can be up to $20,000. So that is not the floor, that is the ceiling. It is up to $20,000. And it is to help ensure that people return to their home country. So that is now fully in place. We have heard that, or I guess Forbes published that there is a potential plan. This is not set in stone yet, but there is a potential plan to have a fee of $100,000 attached to optional practical training. I haven't heard anything else about this. I've just heard that it came out through Forbes, that they are considering a fee of $100,000 for international students to participate in optional practical training. Optional practical training, if you're unaware of what that is, it is the year or 3 years after you receive your degree in the US. 3 years if you have a STEM degree, 1 year for all other types of degrees, where you have an opportunity to work in the US and essentially gain real world experience in, that as relates to the degree which you have just achieved. So $100,000 fee would definitely have a significantly negative impact on many international students, as well as the companies that they would have worked for will not have the benefit of their talent. So we'll see. Again, that is not set in stone. It is not a rule. It is in Forbes' potential plan that we may see. All of these non-definitive words on purpose. So I will definitely keep my eye open on that. We have seen 2 more executive orders come out on citizenship. So a little bit of background. Within the first week, may have even been the first day, it's a little hazy now, but pretty early on in the current administration's term, we had an executive order about who gets citizenship, who becomes a U.S. citizen at birth. It was challenged. It wound its way up through the Supreme Court. The Supreme Court struck it down. Now we have 2 more executive orders discussing who gets citizenship when they are born here in the United States on U.S. soil. So the first one essentially says that if you, it carves out a specific set of people is really what both of them do. So the first one carves out and says, if you are born to parents of a government that is deemed an alien enemy, you are not a U.S. citizen if born here. If you are born to parents that are foreign government employees, you are not then considered to be a U.S. citizen if born here in the U.S. And if you are, quote, engaged in a commercial transaction to purchase birthright citizenship, then, any children of that relationship born in the U.S. are not considered U.S. citizens. So I fully expect there to be some litigation on this. We'll see, but that's what we have right now in terms of the executive order. The second executive order is essentially to prevent what this administration is calling birth tourism. And so it is instructing Department of State, i.e. the consulates, and DHS to come up with changes in their policies that prevent what this administration is calling birth tourism. So that is essentially people that come to the U.S. specifically to give birth. And so, they're potentially looking at revoking visas, not issuing visas, that sort of thing. So that is the second executive order. So again, I fully expect there to be some litigation around the second executive order as well. I will keep you up to date on it. But that is where we are in terms of citizenship and who is allowed to be considered a U.S. citizenship when born in the U.S. So this is all I have for y'all this Monday morning. If you have any questions or you need any assistance, feel free to reach out. We are happy to chat with you, and have a great Monday and a great rest of your week.